Welcome to the Plant Grow REAP podcast.
Hello all, welcome to Plant Grow REAP. My name is Daniel Pachoka, accountant at Aintree Group, and I'm joined today by my colleagues and friends, lawyer Liam McCall.
Hello.
And legal assistant Elektra. How are you guys going today?
Pretty good.
Great.
Pretty good. That is good to hear. So today we're going to be discussing the new right to disconnect law. The right to disconnect law grants employees an enforceable workplace right to refuse to respond to contact outside of their ordinary working hours. Now, before we get into the nitty-gritty, why is this important and why should we care? Well, according to a report by the Australian Institute, Australian workers are on average performing 4.3 hours of unpaid overtime a week. 7 in 10 workers reported having performed work outside of scheduled working hours, while only 3 out of the 10 workers indicated that they have not done overtime. 6 in 7 workers expressed support for the federal government to nationally legislate a right to disconnect that directs employers to avoid contacting them outside of their ordinary work hours. Only 8% opposed this idea. And yeah, as you could all imagine, workers with a poor work-life balance are reported to, request more sick leave, display lower work motivation, work morale, and are generally and statistically less loyal to their employers. So, Liam and Elektra, what is the right to disconnect provision in the Fair Work Act?
So this stems from the Closing the Loophole Bill, which was introduced to Parliament by Senator Pocock, who's from the Greens, and this was following the recommendations from the Senate Select Committee on Work and Care. And this bill amends the Fair Work Act to introduce a high-level right for employees to disconnect, which is the right to not respond to contact from their employer outside of their working hours. These provisions are going to take effect from 26th of August 2024, and that's for all employees and employers under the national system and for those under modern awards. These measures won't come into effect for small businesses, though, until 26th of August 2025. Small business employers, of course, being those with businesses with employees under 15 people. Mm-hmm. And these provisions were introduced due to the emergence of technology and the availability creep, which is mentioned a lot in the Work and Care Inquiry report. So these laws were given assent on the 26th of February, so we can expect to see these come into full force in about 6 months.
Beautiful. Elektra, where did this originate from? And why now?
So it originated, this whole idea of the right to disconnect, I guess, first emerged in France in 2017. And I guess it is emerging in Australia now because it's essentially especially post-COVID, the way that we work has completely changed. It's no longer you just come into an office and it's 9 to 5. People are connected to their laptops, their phones. So essentially when you leave work, that doesn't necessarily mean that you've finished work for the day. So the purpose of this bill or this law is to support people through this changing work environment. So it's to enable people to balance that work life. Mm. So it supports productive work from home, flexibility, the rights and the right to disconnect from your job. So working from home created new patterns of work, as I said before. And as you were saying before, how people are spending so much time working overtime. Mm-hmm. It just shows that the current laws and industrial relations frameworks and institutions, they're not properly set up to protect the boundaries between work and non-work time for many workers in this day and age. Because especially what we have right now, it's at the expense of a lot of people's health and safety and family social lives. So this over-connection to work is turning into an occupational health and safety matter for workplaces as well. So this exposure to long work hours has been associated with increase in anxiety, sleep disorders, depression, psychological conditions like cardiovascular and metabolic disorders. So this right to disconnect enables people to have more family and social time, improve their mental health, experience less stress and anxiety around their job, and their job satisfaction will increase. So I guess it's a benefit for both employees and employers.
Correct. And obviously, we have this right to refuse, right to disconnect. But I guess the main question that everyone's probably asking is, what's reasonable, and where do you draw the line of going to your employer saying, okay, like, you're asking me to work too much. We're going to chat about it. If you're not happy, I'm going to take you to Fair Work. I'll take you to the institutions. So let's talk about reasonableness and how, I guess, the Act and the law defines that, or maybe doesn't define it.
Yeah, thanks, Dan. That's a really good point, is that reasonableness sort of gets into the more difficult legal parts. And for a lot of employers, they might think, well, is there any sort of concrete definition and a way we can delineate between reasonableness and unreasonableness? And it's important to know that when these laws will come into effect, these provisions will read that an employee may refuse to monitor, read, or respond to contact or attempted contact from an employer outside of the employer's working hours unless that refusal is unreasonable. And this is, as I said, one of the more difficult points, because you have to take into consideration a lot of things for what will be considered reasonable, and those could, the law doesn't give us a very, exhaustive list, but things could include, what is the reason for that contact? How is that contact made? Extent to which that employee is compensated, nature of the employee's role, and whether their contact outside of those hours is required under a law. And I think the best way to give examples is then, you're a manager and you're trying to fill in a shift. The store is opening tomorrow morning. I've got no one to open, and you're trying to fill in a shift the night before. Someone's contacting you outside of hours. That's completely reasonable to do so. And even in case of emergencies as well. And let's also sort of not forget that this is not a blanket right. These laws are not formulated to be a blanket right. They are on a case-by-case basis. And it applies to full-time, part-time, full-time and part-time and casual. And based on what we've read, this applies to absolutely everyone.
So would you say that because it applies to everyone, that maybe that's just a conversation that you need to have with your employer to be like, okay, so these laws are coming into place. And also for your employer to be aware at the same time. And how will this impact my employees and how we work and how our business operates? So it's just like a conversation to kind of be had.
Yeah, no, 100%, because we know that not each workplace is the same. We've got to take into consideration how a law firm's going to manage this with clients who have maybe different expectations about what they need, and how do employees with young children or family have a greater claim to uninterrupted time and personal time compared to a single adult with, say, less responsibility. So, yeah, it's important to know where that sort of, that difference lies between what particular role you have and the nature of your job.
Yeah, because like you were saying, like obviously every job is fairly different, and even if it's the same kind of job but different employer, they might have different expectations or different things they want you to do. So even like we were talking earlier this morning about dispute lawyers versus other lawyers, for example, and how it's almost like part of your job is to be available outside of work hours because of what pops up. And so whether you want to talk a little bit more about that, Liam.
Yeah, no, 100%. There is a recent example where our client was served with an injunction at 4:58 p.m. on a Friday afternoon, which is not optimal.
Not uncommon.
Not uncommon. And so, the hearing was set down for Monday morning at 10:30, and that's a bit rough. And then, we get instructions during the weekend, and I get a call from my boss being like, guess what? You're at court tomorrow morning.
Yeah.
And that is, even in my view, and as a dispute lawyer, that's completely reasonable for my boss to be able to contact me and say, I need you at court the next morning. This is incredibly urgent. There are situations which arise. I mean, you think of the alternative, me rocking up to work on a Monday morning at 8:30, 9 o'clock and finding out I've got to be in court an hour and a half and I've got material to read, things to do, instructions to seek from a client. So in each case, for some employees, they need to be contacted outside of work their own benefit.
They're arguably, well, not arguably, they're doing you a favour. Like if you care about your career, and then instead of like you were saying, coming to work at 9 a.m. on the Monday with an hour, not even an hour to prepare. It's they're doing you, I guess, a service. So it's just goes to show that for every kind of industry, every type of employee, it could be different. And whether we want to start and lead that into talking about contracts and employers' contracts yet, or if you guys would prefer to maybe talk about the penalties that could apply, or I guess before we talk about what employees need to do, I guess with their contracts and all their different types of employees, tell me about how the process would work if an employee was to feel like they're being asked to do unreasonable amount of hours outside of work.
Well, I think the first step is if your employer is consistently contacting you outside of work hours and it is unreasonable. Like, for example, me, I'm a legal assistant. So, for example, maybe the partner of my law firm is emailing me, texting me, calling me just because maybe a contract needs to be reviewed and sending me all this stuff to do. That isn't urgent. And that doesn't have to be, I'm not needing to be at court at 9:30 on a Monday morning. So if that continues to happen, the first step would just to have an internal discussion. And that can be with your manager, with HR, because you have a right from, August, you will have a right to bring that up and be like, okay, so I'm going to exercise my right to disconnect and this is unreasonable. And then from there, I guess we would go to Fair Work if they continue to do so.
Yeah, absolutely correct. That's the correct venue to be in is then Fair Work. And if you're an employee, you're seeking an order from Fair Work, a stop order saying this needs to stop. And it's completely at the discretion of the Fair Work, and they'll look at all the material available to them, whether those contacts outside of work hours were reasonable or the employee's right to refuse was reasonable. And that's an incredibly important step. Hopefully it would never come to that, but that is an avenue that an employee can make to enforce their right to disconnect.
Yeah. And so I guess what is, if the employer fails to offer the right or the employee succeeds in their application, what are the penalties?
Right. So if they get this order and they get a stop order saying, please stop contacting me, don't do it again, and the employer does, and they breach that order, it is quite significant. And I hope my math is correct, but it's 60 penalty units for breaching that order, which when these laws come to effect in August, that will be an $18,780 fine.
Yeah, which is pretty substantial, right?
Which is kind of good that it is substantial because it gives employees a bit of power to speak up, because there's always going to be this power imbalance between an employer and an employee. So having that backing, that right, it just levels the playing field and may make some people feel more confident to step up. And, employers should be wary and they need to take this on board and really see what they can do to mitigate this and encourage the right to disconnect in their own workplace. Because otherwise you're going to be paying an $18,000 fine.
Yeah, for sure. And you could argue that $18,000, if you were to hire a similar person for the role, the person that's made the application, if we hired the same kind of person for 10 hours a week, it'd be cheaper than an $18,000 fine, and this other person wouldn't have to work overtime.
Exactly.
You could argue. So I guess that brings us into another discussion we had previously about almost the benefit of this, and if an employee was to make an application for their right to refuse to work extra hours, you could argue could be beneficial to the employers in terms of resourcing and identifying their resource gaps, and
because if their workers are working so much more outside of their hours, well, then clearly there's a resource issue. Maybe you need to take on more staff, or what else can you do? Because you've obviously, you need to grow the business more. You can't just keep relying on these workers, because at some point you're just going to overwork them, stressed, anxiety, and it's just going to create a bad culture. And I think that's one thing that, you were talking about this morning, Dan, is how, especially here at Aintree Group, they're really good at managing. They're asking if you do work overtime, put that time on your timesheet so then they know, and then they can allocate. So what was you were saying that
Yeah,
before, like that was
just
your
in terms of
experience?
for the accounting firm at least, or I guess industries that use timesheets, right? Like,
Mm.
they often, the leaders of at Aintree Group, CA, often talk about, putting your time down. If you're working extra hours, put it in your timesheet, include it in your timesheet, accurately describe it, show that you're working extra hours or something's taken a lot longer to do. Because then, like we were saying about resourcing, we could identify an issue that can easily be fixed or can be looked into further. Even with billing clients, like we often talk about, if someone was to stay back till 6 every night, work on one client all week, and then, let's say that's an hour each day, 5 hours less for this client that we should be billing them to be a profitable business or make them a profitable client. It's I guess that's one part that you're not really looking at. I guess when people are working overtime and not recording it, I guess. So we maybe digressed a little bit, but it's interesting. Like,
there's a lot to discuss around this topic as well. Like another thought I just had was like the fact that we employees are given this right is that a lot of like casual employment and things like that, they're not really, I guess, like unionized, and they don't have like this backing. Their contracts, they don't have contracts usually, like employment contracts that they sign. I remember when I got my first job working at a cafe, no way did I sign an employment contract. I just rocked up one day, did a trial, and got the job or didn't get the job, and then they started paying me some sort of vague wage or whatever. But like, I didn't know I had like a right to do that. And, my manager could contact me outside of hours. Can you fill this shift? Or like even sometimes like I would start at 6 a.m. and I would get a call at 5:30 a.m. or like for like a 6 a.m. start when I wasn't rostered on or something like that. So it's like now everyone has those rights as well. It's not just
like your full-time, more stable
more
employees.
Formal employment sort of style contracts.
Yeah. It's interesting. I guess you just kind of hope and wish, or hopefully this podcast helps in a way, but this kind of law is, I don't know, marketed or advertised a little bit more, and people can be aware of it. Employees can be aware of it. I guess even more employees can be aware of it, so they know the right things to do in terms of employment contracts and how to go about it, which I think we're about to discuss. But just quickly before that, I was also just going to mention how international businesses will also need to be wary of this, which I imagine would be difficult to them because you wouldn't have thought a company in England, unless they were accustomed to hiring Aussies, they wouldn't be looking into like the laws and the rights that a lot of Australian employees get. So that could be an interesting one, and whether that would ever pop up for an Australian employee working for an overseas firm, and like whether the time difference and how that all works and what's reasonable. Like, are you expected to work in our nighttime or during the day and all that kind of stuff. So that's another interesting point. Especially
because the laws are about to change in August. So I guess the international community dealing with Australian companies, they haven't had to deal with this right yet. So now it's coming on board. They have to be aware. But yeah, like for lawyers, if we have clients calling us from America, we're probably going to get an email from them at like 2 a.m.
Yeah.
So I think it is about just having the conversation with your employer and then making it known to your clients and your wider business communities.
Yeah. I was just going to make sure, Liam, did we talk about third parties before and how they come into effect with this right to disconnect?
No, we didn't. That's a really important one to touch on, because these laws also reflect not just on the employee's right to refuse contact with their employers, but also third parties. So it's also clients as well. It doesn't mean that there's some sort of other loophole where, my employee can't or is allowed to refuse or, ignore me, but maybe I'll just get the client to ring him. Right. The employee also has that right to ignore.
Yeah, as in the employee has the right to refuse contact from the third party.
Yeah.
Interesting. All right, so let's get into what I mentioned before, and maybe the question that hopefully all our listeners are wanting to know. As employers, so what do employers need to do to protect themselves?
Well, there's a number of things that they can do, but first they need to review their employment contracts that they have currently now, because it necessarily it may not actually reflect the fact that some roles might actually require out of hours contact. So it's really important that they review that so they can really let those employees know what is expected of them in their role, and if out of hours contact is required for them to do their role. So it must be updated to reflect that with whatever their roles and duties are in that job, and to properly really assess whether they're being compensated for that. And that goes also for position descriptions, because not only are we reviewing our, the employment contracts, but we should also be reviewing our position descriptions, which a lot of employers often don't. They sort of give it out at the start and it's never really updated. But as people go through promotions and seniority through a business, position descriptions must be updated, because the higher up in management you get, there's probably going to be an expectation that you can be contacted outside of work. And I think the Prime Minister said it really well, is that if you're not paid to be on call 24/7, then you shouldn't be working on call 24/7. And that's the basis for that. It's really a really good time to review each employment contract on a case-by-case basis with that role, to know what is it that is required from this employee. Will I contact them? Is it reasonable for me to do so? And include that and let them know.
Yeah, because I'd like to think once this law comes into fruition or is official, there'd be a lot of contracts that, or employers that don't find out about this rule, and they could get a little bit stuck in the mud with employees who may know about it and then just come up to them, or employees who are working overtime, doing unreasonable hours.
But it's also very important to remind employers that it's not as simple as having a boilerplate sort of standard cookie cutter contract where you can say, well, I retain the right to contact you whenever I want. You can't refuse it.
That's just unfair.
Unfair. You won't be able to do that, because it still comes down to, again, as we talked before, it's about what's reasonable. And if it is not reasonable to contact that employee outside of those hours, doesn't matter what you put in that contract, it's still not going to be good enough. So we need to assess it on a case-by-case basis.
Yeah. And I guess you could even argue, if you were to put something that vague in the contract and, an employee actually reads it, or future employee, they just won't take the job. Like, if you're expected, if it's that vague and it's, maybe your wage isn't
doesn't reflect.
Doesn't reflect that amount of how vague that sentence is, or that statement, or part of the contract. It could be interesting and could change a few things. You'd imagine, maybe. Depends, again, case by case basis. I guess, did you want to have a bit of a brief summary of the podcast, in case, unless I've forgotten something that we wanted to talk about? But just let's have a quick recap. I guess so laws introduced, and they're going to be coming into effect from August. Small businesses won't have to worry about it. Well, they should be worrying about it, but they won't be becoming enforceable until 26th of August 2025. And this is going to allow, and again, this is not a limitation on employers. This is a conferral of an enforceable right for employees to refuse to respond to contact. And that whether that be by any means, unless it is unreasonable. And these are going to be, it's essentially catching up with the emergence of technology and the fact of how available people are now. And obviously with COVID assisting that.
Of course.
And all of this,
And it's these laws aren't going to be enforceable until August, so it is a very good time to review those contracts, position descriptions, keep up to date, because you don't want to be caught short. Not with 60 penalty units, absolutely not.
$19,000, and you could argue it's just good to get on the front foot, even with employers, even just like to be even more on the front foot. You could organise a meeting with all your employees and just have the chat with them and maybe let them know that this law is coming into place. Let's agree on an updated contract description or part of your contract condition to get ahead of the game. Unlike, I imagine, a lot of employers who won't and might be unaware of this kind of law. So Yeah, anything extra, Elektra, that we've missed out on?
I'm not off the top of my head,
Mm-hmm.
but I
I
think
think we've done well.
overall it's a positive change in Australia.
For sure.
Yeah.
Mm.
Yeah.
And
no,
it's just
definitely.
adapting to the current modern day working styles. It's, it's no longer the 80s. We've changed.
Correct. And yeah, employees are getting more and more of a right to do certain things. And obviously here they're getting more of a right to refuse to disconnect.
Yeah.
So I guess on that note, thank you everyone for listening. If you enjoyed the show, Plant, Grow, Reap, please rate and review us on Apple Podcasts and or Spotify. And be sure to come back next time to our next podcast. Thank you guys for coming.
Thank
No
you, Dan.
worries. Thank you.
Thank you.